आपको सीधे लिए चलते हैं, मुख्य न्यायाधीश जो सेवानिवृत्त हो रहे हैं रमन्ना साहब, उनका भाषण चल रहा है, वो सुनवाते हैं।
At times, the circumstances may not allow him to score even a single run. The advocates are best placed to understand this predicament of a judge and dispel wrong notions about them. Here I would like to read out the senior advocate, Mr. Sanjay Hegde, wrote in a newspaper article, I quote, "This is in the context where I have decided a case of Anuradha Basyan, where right to speech, right to access to internet, etc. There is a criticism that I have not given full relief." I quote that article. When a senior advocate asked Justice Bhagwati about the dichotomy between the reasoning and the relief, that is in Maneka Gandhi and R.D. Sethi, the judge explained that his brother judges were only concerned with the relief being denied in those cases. As long as Justice Bhagwati followed their lead on the relief, he got to write the judgment and lay down doctrine of law that continued to operate deep into the future. Every lawyer who today wins on the basis of R.D. Sethi and Maneka Gandhi judgments owes his victories in no small measure to Bhagwati's foresight, unquote. In earlier days, the bar used to play a proactive role in the resistance. The members of the bar used to willingly associate themselves with various social causes. It is the legal battles initiated by Bar Association that have led to progressive interpretation of the Constitution. It is in this spirit that bar must work to strengthen democracy. One aspect that I want to bring to your notice is my choice of traveling across the country almost every weekend to speak to the public through various events. The popular perception is that the Indian judiciary was alien and quite distant to the general public. There are also still millions of suppressed people who need judicial help, who are apprehensive to approach the judiciary in times of need. My experience so far has convinced that in spite of fulfilling its constitutional mandate, the judiciary does not find adequate reflections in the media, thereby depriving the people of knowledge about the courts and the Constitution. I felt it was my constitutional duty to dispel these notions and bring the court closer to the people by way of generating awareness and building confidence among the people about the judiciary. From what I get to hear from the common people during my visits, I am happy to note that people are able to engage with me on my subject in their language. I have actively tried to promote a sense of belongingness of the people with the system. My constant endeavor was to make the people aware not just about their rights and obligations, but also about the constitutional scheme and democratic values and the institutions. My sincere efforts was to initiate a dialogue. As a part of my public speaking engagements, I have focused on certain subjects of institutional importance. The focal point of any justice delivery system is the litigant, the justice seeker. But our system, practice, rules being colonial in regime may not be best suited to the needs of Indian population. The need of the hour is the Indianization of our legal system. When I say Indianization, I mean the need to adapt to the practical realities of our society and localize our judicial delivery system. I have pushed for modernization of judicial infrastructure as a means of providing access to justice. I also tried to highlight the difference between the arrears and backlogs to put things in perspective.